Good afternoon. Welcome to today's Dean's Distinguished Lecture. As you may know, we instituted this lecture series a few years ago to give us an excuse to bring back our most successful and interesting alumni to campus to speak with students over lunch.
And then there was me.
And you fit the bill on both counts. In 1886, the year before this law school opened its doors, Cornell President Andrew Dixon White said that he hoped that the graduates of Cornell's law school would become, in his words, a blessing to the country at the bar, on the bench, and in various public bodies. And I think when he said that, he had in mind different people, right? That some people would succeed on the bench, some people at the bar, some in various public bodies. But today's speaker defies that interpretation. It's no exaggeration to say that over the course of his distinguished career, he's excelled in all three areas. The Honorable Stephen C. Robinson is a member of Cornell Law School's class of 1984. He's also a graduate of the College of Arts and Sciences, class of 1981. He's worked as a big law partner in government service, on the judiciary, as corporate in-house counsel, and in private investigations. He's thrived in all these roles, in fact, so much so that he did not apply for most of the positions that I just described. Since 2010, Judge Robinson has been a partner at Skadden Arps in the firm's New York City office, where he handles a variety of litigation matters representing clients like Citibank, Capital One, and Toyota. He serves as co-chair of the firm's Global Diversity Committee and is a member of the advisory board for the Skadden Fellowship. Before joining Skadden, Judge Robinson served as a U.S. District Court judge for the Southern District of New York, to which he was appointed by President George W. Bush in 2003. Prior to becoming a federal judge, Judge Robinson had served as the United States Attorney for the District of Connecticut under President Bill Clinton. He's also served as Principal Deputy General Counsel and Special Assistant to the Director of the FBI. He was involved in investigations of espionage and the Oklahoma City bombing. And he served as a Managing Director at Kroll Associates, the private investigations firm. In his spare time, Judge Robinson has taught classes at Cardozo and Yale Law Schools. He's on the boards of the Lincoln Center, the Federal Bar Council, and the Brennan Center for Justice, among many others. But he's not forgotten his alma mater. Judge Robinson has been a longtime member of the Cornell Law School Dean's Advisory Council and a regular speaker at our 1L orientation, where many of you probably met him. We're here to survey Judge Robinson's accomplishments. I'm confident that A.D. White would agree that he truly is a blessing to the nation. Please join me in welcoming the Honorable Stephen C. Robinson.
Well, thank you. It's always so nice to be back here at Cornell. So thank you, Dean, for inviting me back to the law school to deliver this speech. As some of you know and have heard me speak before, I use these opportunities to say all of the things to you, a somewhat captive audience, that my daughter would never sit still for. And today is no different in that regard. In fact, while my daughter might let me get out my first life lesson before she rolls her eyes and begins her tsunami of texting, she would never allow me to talk about the law. And so I will start with words of thanks to all of you for showing up, because more than the hope for reality that you'll find me interesting or perhaps even learn something, these sessions are very therapeutic for me. And so bear with me as I rant at you for a little bit. We as a nation are going through some very, very challenging times. Times that make us confront who we really are versus who we aspire to be. Times that make us re-examine the meaning of the words that we claim to revere. This past July 4th, we celebrated the 242nd anniversary of the Declaration of Independence. And we still struggle today to cast full meaning to those words that were a statement of aspiration those many years ago. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among those are life, liberty, and the pursuit of happiness. Those words were aspirational because when they were written, this country still enslaved people of African descent. Women were still 144 years away from being granted the right to vote, and Native Americans were in the process of having their land stolen from them. Today, we still face challenges giving effect to that declaration. We have challenges because we do not have leaders who see it as their solemn obligation to represent that American spirit. We do not have elected officials who stand up for the fundamental rights of all men and women and gay and lesbian and transgender and queer, who do not stand up for the rights of all of us. We are constantly bombarded by those who lie and promote absurd yet damaging conspiracy theories for sport and for profit, and refuse to recognize that there are indeed facts. We elected officials who lead by dividing us and who have no moral center guiding their actions. As a result, in America today, there are no facts. This is a very dangerous and troubling moment, because if there are no facts that we accept, if there are no facts that we can agree upon, how can there be any truth? Truth is dependent upon some shared understanding of facts. If there's no truth, if all facts are instrumental, then we as a people are lost. We are left careening from one lie to an alternative fact to a baseless conspiracy theory based on simply how our wants guide us. If there are no facts, there can be no truth. And if there's no truth, there can be no justice. And so there can be no self-evident truths about what all men and women and gays and lesbians and transgender and queer and others are looking for. I believe that lawyers today, whatever their political beliefs, must play a crucial role in trumpeting the fundamental principles of our democracy. I believe that we must go back to the democratic aspirations recited in the Declaration of Independence, that some truths are self-evident. It is my position that lawyers must lead the charge, and they must lead the charge to do at least two things. One, protect a rule of law that is grounded in respect for the dignity of the individual. And two, maximize the capacity of individuals through honest, reasoned, and enlightened legal process and government. Law so grounded, in my view, makes justice possible, for only through such law does the dignity of the individual attain respect and protection. Without it, individual rights become subject to irrational and unrestrained power. Respect for the law is destroyed, and rational self-government becomes impossible. I believe that lawyers must understand themselves as having a unique obligation to the rule of law that is foundational to our political economy and to our constitutional democracy, including contributing to access to justice, strengthening the rule of law and the legal institutions of the United States. So let me talk to you for a moment or two about two stories you are all familiar with, and suggest to you how lawyers in one circumstance upheld the highest ideals of our profession, and discuss briefly in the other circumstance where I believe a lawyer fell short. I will then talk a bit about how my own existential crisis forced me to re-examine the meaning of my own career as a lawyer and as a government and public servant, and how I've begun to make a course correction at this stage of my professional life. First, let me start by reading to you part of a story written just 4 days after we celebrated the 242nd anniversary of our Declaration of Independence this past July 4th. A reporter for the Associated Press was giving an account of the aftermath of the president's crackdown on illegal immigrants. The reporter wrote, quote, "His name is Johan. He drank a bottle of milk and played with a purple ball as he waited for the immigration judge. John W. Richardson, the judge at the Phoenix courthouse, said he was, quote, embarrassed to ask, close quote, if the defendant understood the proceedings. I don't know how you would explain it to him unless you think a 1-year-old could learn immigration law, he told Johan's attorney. The boy had been separated from his father, who had to leave the United States for their country of Honduras under the impression that his son would go with him. Johan is one of several immigrant children who have had to appear in court without their parents present. Among the defendants were a Guatemalan boy dressed in a vest and tie who simply put up 5 fingers when asked his age, and an acquiescent 7-year-old girl in a pink bow dress. Earlier this year, the Ninth Circuit Court of Appeals ruled that undocumented children are not guaranteed court-appointed lawyers. The court said that, quote, "It is not established law that alien minors are categorically entitled to government-funded court counsel." When I put all of that together, I find myself asking, is that the aspirational America our founding fathers talked about 242 years ago? Have we forgotten that 8 of the signers of the Declaration of Independence were themselves immigrants? Or that 3 of the original Supreme Court justices were immigrants? Or that 4 of the first 6 secretaries of the Treasury, including the very first Alexander Hamilton, were immigrants? In his letter from a Birmingham jail, Dr. Martin Luther King taught us that our goal is to strive to achieve justice in this imperfect world. We cannot achieve justice until we see others as ourselves. He said, quote, "We are caught in an inescapable network of mutuality, tied in a single garment of destiny. Whatever affects one directly affects all indirectly." So if we as individuals don't see what is happening to immigrants and others in this country as affecting us, we are lost. If we allow the pursuit of riches to overwhelm our humanity, we are lost. If we don't look at our neighbors, our fellow countrymen, our fellow human beings, and see ourselves across political lines, across regional lines, across economic lines, if we don't see them as ourselves, we are lost. If we have not heard the Reverend Dr. Martin Luther King Jr. shouting through the decades from that Birmingham jail, we are lost. I'm not suggesting that the United States allow unfettered immigration. There, of course, must be rules and process, but shouldn't we demand of ourselves that those families who want to come to America for a better life be treated with respect, dignity, and compassion? They are, after all, looking for the same unalienable rights that we supposedly are granted by the Declaration of Independence. The writers of the Declaration, our founding fathers, surely didn't contemplate a 1-year-old child appearing in court without their parents being asked by a judge if they understand the immigration laws. Whether immigrants are right or not to have crossed our borders in the pursuit of life, liberty, and happiness, we owe it to ourselves to treat them with dignity and humanity. We owe it to ourselves because we are tied in a single garment of destiny. We owe it because we claim to believe that when we watch, when we watch our parades and fireworks celebrating our declaration on July 4th, that this is a country for all. So with respect to these new immigrant policies, lawyers led the charge towards a more compassionate and just America. Hundreds of lawyers swarmed airports around the country to provide legal advice and accord these families with the dignity and process that they deserve because we believe ourselves to be a just and compassionate place. As was reported in the New York Times, even before the president issued the order banning immediate entry into the United States by people from several predominantly Muslim countries, immigration lawyers, having heard rumors of coming action from the White House, were on alert. Lawyers from the Urban Justice Center, who were concerned about the action, how that action would affect their project's clients, sent out an email calling for lawyers who would volunteer immediately to go to airports where refugees were scheduled to enter the United States. And that's exactly what happened. across the country, people were detained on Sunday after being caught in the aftermath of the president's orders. Lawyers who heeded the call of the Urban Justice Center were at about a dozen airports around the country. Others who heard about the effort through colleagues or news media went to airports on their own to pitch in. By early Sunday morning, lawyers offered services and advice at most international airports across the United States. At Kennedy International Airport Terminal 4, where I was, that terminal was entirely overtaken by lawyers, all working to file petitions for individuals with the help of clients and their families. There were attorneys from numerous major law firms, there were attorneys from nonprofits, there were independent attorneys all working together, and it was a glorious sight. While lawyers gathered at airports, others were working furiously on litigation and a petition that led to the judge's stay. This was lawyering in its best sense. This is an example of lawyers fulfilling their role to protect the rule of law that is grounded in a respect for the dignity of the individual. Despite these efforts, we sit here today on this most Ithaca of Ithaca days. We sit here with more than 245 children, one for each year of our Declaration of Independence, with a few thrown in for good measure. 245 children remain in U.S. custody, housed in what can only be described as internment camps. Most of the 245 children in custody have parents who were removed from the United States without their children, and as we sit here today, it is clear that we don't know where those parents are or how to reattach them to their children. On the other side of the equation, there was a highly publicized example of a lawyer who, in my view, failed to fulfill the lawyer's responsibility and role to protect and minimize the capacity of the individual through the honest, reasoned, and enlightened legal process. This occurred during the confirmation hearings for Justice Kavanaugh. As you have heard in my introduction, I spent much of my career in law enforcement. I was a federal prosecutor as a line AUSA in the Southern District of New York. I was the Deputy General Counsel of the FBI. I ran an office of federal prosecutors as a U.S. attorney in Connecticut, and I sat as a federal district judge in the Southern District of New York. And now as a partner in the white collar and government enforcement group at one of the largest and best law firms in the world, I spend my time trying to use the investigative and fact-finding tools of the legal system to resolve problems of individuals and companies. Those disputes involve contested versions of sets of events and contested versions of facts that happened sometimes months and years ago. I and others who do this work and make our living figuring out methodically who did what, when, where, how, and to whom. And we do it in adversarial proceedings in which each factual assertion must be sourced, cited, and proved with evidence and testimony. There is nothing arcane or even legally difficult about the investigative steps a real investigator and a real lawyer could have taken on behalf of the Senate Judiciary Committee to reach a reasonable factual conclusion about the allegations against Justice Kavanaugh. But the Senate Judiciary Committee is not a court of law, and those hearings were not about the search for the truth. They were political theater which each side trying to score its political points. This particular Judiciary Committee's approach to the Kavanaugh hearings presented a false image of the work of prosecutors, or for that matter, even good lawyers, suggesting that it is little more than just throwing two people against each other and letting the jury, or in this case, the public, decide whom to believe. But that is not what our legal process is. When both sides have adequate resources, an important caveat, trials and the periods of documentation, production, and deposition testimony that lead up to them are extraordinarily good vehicles for arriving at what I have always called the courtroom truth. I have always separated that from what actually may have happened in reality. but what happened in the context of the courtroom where certain evidence and testimony is allowed to be heard. It's common, moreover, for lawyers to investigate and litigate allegations of decades-old behavior. That is nothing inherently unfair in a proceeding that seeks to uncover those kinds of facts. However, prosecutors in this country are held to a different standard than lawyers. Chief among those standards is that they must not act in a politically partisan way. Rachel Mitchell, as an active Arizona sex crimes prosecutor hired by the Republicans on the Senate Judiciary Committee to question Dr. Christine Blasey Ford during the Kavanaugh Senate confirmation hearing, used her current position as a generally respected prosecutor to leverage the partisan position of the Republicans on the committee. I think this is a very destructive and dangerous choice. Forget for a moment whether she did a good job or not. In my view, Ms. Mitchell never should have taken that role. Let's be clear about a couple of points. One, the Republicans on the Senate Judiciary Committee could have hired a lawyer to question Dr. Ford and lob softballs to Justice Kavanaugh. Although unusual, that would have been fine. They could have even hired a former sex crimes prosecutor to do their bidding. Again, fine. They further could have found a former sex crimes prosecutor who was a woman to question Dr. Ford. That would have been okay. They could have done any of that to distract us from the scolding lineup of old white men bristling at the notion that a woman could accuse a man of assault that happened years before. I have little problem with any of that. But to choose to trumpet a sitting prosecutor for this role was just wrong and likely a violation of the District Attorneys Association National Prosecution Standards. Let's be clear, in many parts of the country, being a local or a county prosecutor is a part-time job. Those prosecutors also take on private clients. However, the National Prosecution Standards say that if a prosecutor is representing a client outside of her duties as a prosecutor, she cannot indicate her status as a prosecutor in any announcement or communication involved in the private matter. In gleeful disregard for that generally recognized prohibition, the Senate Judiciary Committee members highlighted her day job as a sex crimes prosecutor. In fact, it had been reported that the committee interviewed over 30 sex crimes prosecutors before selecting Ms. Mitchell. One might ask themselves, why couldn't they find a former sex crimes prosecutor? Certainly they are abound in this country. Why didn't they find their equivalent of Robert Mueller, that is, a widely respected ex-prosecutor, to jump into the fray? I don't have to convince you that there would have been hundreds who would have reveled in the spotlight of that high-profile representation. It is clear why the Republicans on the Senate Judiciary Committee wanted her. The presence of an active sex crimes prosecutor served several purposes all at once. It telegraphed and enhanced skepticism of Dr. Ford by an otherwise seemingly objective professional. Why would she take this job if she thought that Dr. Ford was telling the truth? It leveraged the weight and imprimatur of a prosecutorial office on the side of Republicans on the committee. Why would you say that she was an active sex crimes prosecutor in Arizona? For the legally unsophisticated viewers, it lent an air to the proceedings, indicating that this was somehow a semi-judicial process with the requisite procedural and evidentiary protections, and of course, it was not. It also helped that they would have a woman as their agent provocateur. As you might guess, I don't think Ms. Mitchell should have allowed herself, whatever her political leanings, to be drawn into these proceedings in the way that she was. In my view, she had a higher obligation to protect the standards prosecutors swear to uphold, protections that protect our legal system. What I fear has happened as a result of her participation is that every time a prosecutor stands up in a courtroom, a juror could rightly wonder what is their political axe to grind, because no one who watched those proceedings did not think that that was a political game going on there. I believe that this breakdown of established and appropriate norms dragged a public lawyer into a political mess and thereby diminished the role of the lawyers in their best sense and minimized their capacity of the individual to do honest, reasoned, and enlightened legal work. So what has all of this meant for me? It has caused, as I suggested earlier in the presentation, an existential crisis. I spent most of my career protecting the institutions of this country because I believed that that was the way for positive change. In light of the decisions of this country in the election at the ballot box, and in light of actions that are praised in the press, I wonder whether or not I made the correct choice. And so for me, it meant that I had to re-examine and have to constantly re-examine the role that I play today. So the dean mentioned some of the things that I do for Skadden. I serve on their diversity committee. I represent clients. For me now, some of that has suddenly become unavailing. And so I said I must do something very different with whatever skills I do have. So in addition to what the dean has mentioned, I serve as the only civilian in what is called the Hanshu Committee for the New York City Police Department. The Hanshu Committee is a committee that initiates and continues all of the terrorism investigations in New York City. And the concern about that committee that led to a consent decree was that that committee was unfairly targeting Muslim Americans. And since I view those people as myself, though I am not Muslim, I felt it was important that there be someone in that room who could make sure that the investigations that are necessary are conducted with appropriate predication and evidence and thoroughly as we move forward. I serve as a federal monitor for fair housing in Westchester County. Because although I no longer live in Westchester County, it became important to me to touch back on a community of people who need the fundamental parts that sustain our life. I serve on the board of the New York Community Trust. The New York Community Trust was an entity that was incorporated in the 1920s by the very rich New Yorkers, the Rockefellers and the Morgans and the Stanleys and the and the Peaks and others. I started trying to think of people that you would know. But what they did was started to throw money into a fund for what they said was the betterment of New York. And today the New York Community Trust sits on a $2.8 billion endowment. Our job is to give away $250 million a year to organizations for the betterment of New York City. I serve on the board of the Innocence Project because I think it's important for us, whether you are a prosecutor or not, to always keep an eye out that this process is working appropriately and well, and to call to account when those individuals or processes are not working well. And so it has been one of my greatest joys to participate in the dialogue that led to strategies that helped us look at people who were wrongly convicted. If any of you ever have a time or a chance in any community that you work in to be involved in the Innocence Project, I would suggest you do. For a couple of reasons. One, there's literally nothing bad about it. There are a few organizations, a few things where I think there's literally nothing bad about it. It's an organization that seeks to find people who were wrongly convicted of a crime that they did not commit and have spent time incarcerated. And if any of us could then think of them as being us and what it must be like to serve 18, 20, 30 years in jail for a crime that you did not commit, it's an incredible thing, and it's an incredible process to try to help people get to a more just place. And so the way I've taken to think about the last portion of my career as I grow old is what is the relationship that I want to have to my city and to my community? I have done a lot of things. Some of them I did because I thought would be fun. Some of them I did because I thought I would learn or gain knowledge from them. Some of them I did because I thought largely they were the right thing to do. But what I've taken on doing is trying to think about everything that I devote my time and energy to. How does that help some individual who is only trying to get to what we all talk about in our declaration, that they are availing themselves of their unalienable right to the pursuit of happiness and life and liberty? Well, thank you, folks. Thanks for coming. I really appreciate coming back.